Hey everyone, Harry here to talk about the Texas Supreme Court decision reinstating a very narrow, very draconian abortion law that legislature passed in the wake of the Dobbs decision. So the law that the legislature passed says that abortions may not take place after a certain time period, but permit a exception that's very narrow for life being, if in the good faith judgment of the doctor, and of course that hovers over the whole thing, the possibility of a doctor's making a good faith judgment and being subject to criminal penalties. Without an abortion, the woman might die or have a serious risk of substantial physical impairment unless an abortion is performed. So a group, the Center for Reproductive Rights filed a lawsuit, but included in the lawsuit was the testimony of women who have been very severely threatened or harmed under this law. So in particular, the law does not permit an abortion, even if it's clear that the fetus will die. So the fetus isn't viable. You nevertheless, in the absence of any exception, can be required to carry it to term. And there's a whole lot of sort of medical jousting and back and forth about what it means to have substantial physical impairment. So they have a testimony of a woman who was really experienced a lot of bleeding, went into sepsis, but they refused under the law to provide an abortion. And when the standard finally was satisfied in the statute, by that point, when an abortion was performed, she is now infertile. So instances of really severe harm to women, but short of, or that's the argument, the substantial physical impairment that the statute requires. So they brought a lawsuit, and as often happens in the law, first you move to just freeze the lawsuit, get an injunction, and then put on a whole trial about how whether the law is unconstitutional or should be somehow revised. And they moved for that injunction, and a trial level judge, gave them the injunction and essentially reformed the statutory standard to say the good faith judgment, the good faith judgment of the doctor. But if there's a good faith judgment of the doctor that it would be medically unsafe for a woman to continue a pregnancy, or if her fetus has a condition making it unlikely to survive the pregnancy and sustain life after birth. So the guys, or as an exercise of interpreting exceptions in the Texas law, the trial court judge, who unfortunately in these matters you have to designate as a Democrat, said that we're going to change to give a little bit more room in the joints. Reasonable medical judgment of a condition making it unlikely the fetus would survive or would be medically unsafe. So we've defined exactly what the area is, right? It's medically unsafe, but not a substantial risk of physical impairment or death. Can you get an abortion then? And the perfect instance of this, or example, is this woman, Amanda Zarowski, who pregnant 18 weeks, and the fetus wasn't viable, but they could still detect a heartbeat. They said in the unviable fetus, they didn't abort. She wound up going into sepsis and having grave, conditions that anyone would say was unsafe, but substantial impairment of a major bodily function, as the statute says, not clear. So, now it is clear, because now it goes to the Texas Supreme Court. and they unanimously overturn the injunction. The group, by the way, was 22 women and abortion providers as well as this group. And the decision, was a little bit made a nod toward sympathy of people who are in really terrible, some filled with immense personal heartbreak. The court's 38-page decision. And there was actually a point where a recess had to be ordered because of the testimony, but all in all, the court, in a pretty antiseptic but straightforward exercise in interpretation, said, look, the law says before death or serious physical impairment. And they basically construed the testimony as saying, if what you're telling us is true, you really would be. Here's an important quote from the opinion by Justice Jane Bland, who, by the way, it's an elected Supreme Court, 9 of them all Republican and all Texas-style Republican. A physician who tells a patient, your life is threatened by a complication that has arisen during your pregnancy and you may die, or there's a serious risk you will suffer substantial physical impairment unless an abortion is performed, but the law won't allow me to provide an abortion in these circumstances, is simply wrong in that legal assessment. So they see this as doctors shying away, even in situations where there might be substantial physical impairment. But guess what? That's the whole point of the law, because the law provides for criminal penalties. And so will a provider risk its license and a criminal penalty when later that they could have to fight over what the good faith judgment was? That's sort of the whole point and in the kind of operation at the margins of this statute. So anyway, 9-0. They overturn the trial court determination that expanded the exceptions, and now back to legal procedure. Remember, this was a way to get an early freeze of the law, so not go into operation, at which point you then do a whole trial and determine how to interpret the law according to the Constitution. Now there's really no point. They've refused to grant an injunction, and technically it's a different thing. Injunction is a high standard where you have to show a 4-part test and real damage if they don't change it, and imminent harm and the like. That goes away, but there's no point really. It's the suit probably will just fold up quietly, because why go through the whole thing? 9 members of the Texas Supreme Court have already signaled very clearly that this ain't going anywhere, and women who present with very serious physical complications, but not one that a doctor is willing to say in his good faith judgment equate to a substantial risk of physical impairment, are not getting abortions in Texas. So the sweep of draconian laws post Dobbs continues, and Texas is one big state. So there are women who are at really grievous risk of not getting medically necessary or abortions in situations where they're required for their safety, but not to avoid substantial physical impairment. And that's how that is working out now and will going forward is, a matter of intense and kind of urgent speculation. But the Texas law, back in its most sort of vigorous and draconian form, and it's not enough if a baby's not if a fetus will be born not viable, not enough if really very bad medical consequences short of substantial physical impairment as that's interpreted by doctors in their good faith judgment, afraid, nevertheless, cowed almost certainly by the prospect of criminal penalties if they're wrong. Not enough, have to be all the way to death or serious physical impairment will ensue. So a very narrow channel indeed, and reaffirmed. And I think the lawsuit is, if it doesn't just go away, is sort of an exercise in futility. Talk to you later.